1-866-95-PATRIOT. Robert, California. You're on the Wilkow Majority. Hello.
Good. Thank you. By way of preamble, I told you, screener, I'm a constitutional law professor at UCLA Law School.
Okay.
By way of preamble, what do you mean when you say we're right, they're wrong, and that's the end of the story?
Well, you're asking two different things. When I wrap up a segment, I say we're right, they're wrong, meaning the people that I'm analyzing or disagreeing with or whatever. Are you calling to discuss the Constitution or my radio, the formatics of my radio program?
Well, I was just curious because I wanted to have honest dissent with you, and I wasn't sure that was possible given that statement that you make at the end of
Well, it's entirely possible, sir. I mean, hold on. The policy of the program is that people who disagree with me go to the front of the line, and I never draw first blood. As long as the person who's disagreeing with me is civil, I remain civil. The minute it turns course, I become coarse. So go ahead with your point.
I'm civil, but I'm trying to understand the syllogism where you're right and we're wrong. How does that?
Are you playing a game of criticizing the formatics of the program, or do you want to pick an issue and have a debate?
The issue is I don't believe that your knowledge of the Constitution really passes muster, and yet you invoke it quite a bit.
Okay, so what have I said about the Constitution where I've been wrong?
You say lots of things. I heard you show a number of times.
Okay, so give me something where I'm wrong. Listen, sir, if you're a law professor at UCLA, you should be able to slam dunk me and make me look like an idiot with ease. So go ahead, make me look stupid.
Well, that's not my intent. My intent is when you make statements about the administration perverting the Constitution, not following the Constitution, you lose me. I don't know what you're talking about.
Okay, well, which point?
Any of the points you said. I haven't memorized.
Is it the limits of the judiciary as described by Article 3, the limits of the Congress as the 18 enumerated powers, the 10th Amendment giving powers to the states? Let's talk about something. Would you like me to pick the topic? You're the one that called me.
I would only like you to respond when you say that the administration perverts the Constitution. What are you referring to?
Okay, when you take an organization like the American Constitution Society that has this belief that language is constantly evolving, therefore the Constitution evolves with language, that to me is nonsense. That means people can just redefine language and then go, oh, look, well, back in the day, the General Welfare Clause meant this, but today welfare means granting of products and services at taxpayer expense to recipients in our society. Look, it's there. It's constitutional. That sort of thing, sir.
All right, well, let me ask you a question. Do you understand that part of the Equal Rights Movement, when it was proliferating, was revolving around the Commerce Clause? Do you understand that?
The Commerce Clause.
That's correct.
Okay.
Okay. And I assume from your response you were not even aware the Commerce Clause was integral with respect to the Civil Rights Movement.
But so what you're saying is, if you find a higher purpose, sir, that you can twist your.
I'm saying to you is that laws are interpreted.
Oh, so they don't actually mean anything based on the text and the purpose. It's whatever an unelected person in a black robe thinks it means.
Not at all. Not at all. And by the way...
Well, let me ask you, Mr. Law Professor, which is superior, case law or legislative law?
You're misinterpreting.
No, I'm not. You're telling me...
The Constitution is interpreted.
Okay. No, where does it say that in the Constitution, sir?
It doesn't say that anywhere.
So you're inventing that, sir. Tell me where this...
Bible, Mr. Wilkow.
Tell me where in Article 3 the Supreme Court or the judicial branch gets the power to, quote unquote, as you say it, interpret it. I have the Constitution open. I have Article 3 in front of me. You tell me where there's this interpretive clause.
The judicial body that is...
So it's not there.
I'm answering the question, but if you don't want to let me answer the question, I won't.
Okay, you're the victim. Go ahead.
Okay. I'm the victim. Well, your pejorative is not appreciated, sir. The judges of this country, state or federal, interpret the law based on the facts that are presented to them. Just the same as the Constitution, when issues of constitutional import are presented to the Supreme Court.
But what is the basis of their interpretation? Sir, hold on a second there. Now you're leading us astray. The Supreme Court is to interpret a law that is created based on the Constitution and its text, not their own interpretation, not an internet. He hung up on me. He hung up on me. I don't know what this is. I don't find anywhere in the United States Constitution the power of the Supreme Court to interpret the Constitution or of the appellate courts to interpret the Constitution. They can use the Constitution to interpret an unconstitutional law. But nowhere in this document does it say the court created by this document has the power to reinterpret this document, sir. I don't know where you're getting this from. I simply do not understand. Now, I gave this gentleman perfect opportunity as a UCLA law professor to make me look like a fool with all of his extensive knowledge. But maybe this is the way he runs his class. You see, I don't have a grade at stake. I don't have a grade at stake. I'm not worried that if I defeat him in a debate, he may sink my career. He hung up on me. I didn't hang up on him. As far as calling him the victim, this is a tactic to say something, and then the moment you may be interrupted for clarification purposes, oh, you going to let me finish? Can I finish? Am I going to let me finish? Oh, this is what you people do. You talk up. Clarification, sir. You have all the time in the world. The floor is yours.